In other news, the battle over BDS again thrust into the public eye, and particularly regarding anti-BDS laws, which withhold state funds from companies that engage in the anti-Israel boycott movement. The reason? Because while many courts have overturned anti-BDS laws, arguing they infringe on free speech, Arkansas's appeals court is now upholding it. With me to explain what this means is attorney and senior counsel with the Lawfare Project, Gerard Filitti. Gerard, thank you so much for being with us. Now, first off, can you briefly lay out the arguments in the Arkansas case?
Well, first, thank you for having me. This case is a very significant victory in the fight against discrimination. And it was held by the Eighth Circuit Court of Appeals, which is the second highest level of court beneath the U.S. Supreme Court. This is a very important decision for that reason. And the argument there is that anti-BDS laws are a proper exercise of the state's power. The state is empowered to regulate commerce, just as it is empowered to fight discrimination, and that engaging in BDS conduct can be properly banned. It's not a First Amendment issue because it doesn't regulate speech. It regulates conduct, the actual boycott. And the important thing here is to remember what BDS actually is. BDS is naked discrimination. It's targeted discrimination based on national origin and ethnicity, targeting Israelis. Its effect is discrimination against Jews that perpetuates Jew hatred. So having the Eighth Circuit come out with a ruling saying that anti-BDS laws are proper and can be enforced is a huge win in the fight against discrimination.
Well, if that's the case, why did so many other states reverse the anti-boycott laws?
Well, a lot of courts got it wrong, quite frankly, and it has not been litigated on appeal to the level that this case has been. So this is a seminal decision that lays the groundwork for other appeals and enables other courts to rule appropriately. It basically allows states to come back based on the reasoning here and say that this is a valid exercise of state power, and it's not infringing on First Amendment rights, but rather regulating conduct that's discriminatory and improper.
So could anti-boycott laws truly provide a slippery slope for compelled economic decisions in other fields? For example, some say that the law paves the way for other statewide bans on boycotts related to fossil fuels or firearms.
Well, the problem is that there is a legitimate power and an interest by states to have regulatory authority over commerce. So yes, it is possible to have laws targeting other sectors and other industries. But the issue is this is discriminatory. It's not an economic, BDS is not an economic choice. The intent there is to target Jews with discrimination. And that's why this has received so much more emphasis than banning fossil fuels or other regulatory action. The underlying premise of BDS is discrimination. It's not economic. That's the way it's couched. And I think the court saw through that and sees that you cannot impose economic consequences instead of engaging in speech. Speech is protected, but actually targeting companies and people with discrimination is not.
I mean, in effect, doesn't this extend issues that do impact speech, however? Because, in the Arkansas case, you have the Arkansas Times versus the University of Arkansas saying that they're divesting from us and hurting our business simply because we're not signing a pledge of some sort that is being imposed on us.
Well, the pledge is really part of a contract. You are agreeing to abide by the law, and the law says that you can't discriminate. So that's not compelled speech. That's merely incident to the behavior, which is a commercial dispute. It's not speech. The Arkansas Times is free to write op-eds and editorials condemning whatever it wants to condemn and being as hateful as it wants to against the Jewish people, but it's not allowed to engage in commercial discrimination. That's the distinction in the law. So speech is still permitted, that's not infringed upon, but you can't engage in conduct that is illegal.
So could the appeals court ruling set precedent to reverse other states' decisions to overturn the anti-BDS laws?
I think this opinion is very valid in the Eighth Circuit, and the states that are part of the Eighth Circuit. So those states are emboldened and empowered to fight to uphold their anti-BDS legislation. But more importantly, because it's the highest court that's issued a ruling on this, it will serve as guidance to every state, essentially, in allowing them to argue that anti-BDS laws are proper and that they need to be enforced.
All right. So first of all, what other states are included in the Eighth Circuit Appeals Court? And of course, you also then have the Arkansas Times, and the ACLU, who defend them, saying that they'll go all the way to the Supreme Court. So if they go to the Supreme Court, would that ruling then extend nationwide?
If they go to the Supreme Court, first of all, the case has to be heard.
Right.
And there have not been conflicting opinions coming from other circuits. So it is not likely that the Supreme Court will take up this issue in a writ of certiorari. So this decision is likely to remain, at least until there's some opposing law or there are some different issues for the Supreme Court to hear. So this is going to be in force for a while. Appeals are not likely to be successful.
All right. Gerard Filitti, thank you so much for joining us.
Thank you for having me.
Hi everyone, it's Emmanuel Kadosh. I wanted to invite you all to subscribe to ILTV+, where you can find our daily news and updates about Israel. And not only that, but live feeds, entertainment, our kosher food show, and so much more. Needless to say, your subscription to ILTV+ helps us grow and create more content while also supporting the state of Israel. Our app is available on all platforms and devices, so I'll see you guys there.